right, we begin this hour with new details in the deadly no-knock raid that killed Amir Locke in Minneapolis, Minnesota. Locke's cousin was arrested today and charged with 2 counts of second-degree murder. This is in connection to a deadly shooting that happened last month. The cousin is 17 years old and currently being held in a juvenile detention center. Prosecutors are moving to have him tried as an adult. Joining us now is attorney Bianca Ford, former federal prosecutor and global compliance executive. Bianca, it's good of you to join us at this hour. Based on what we know so far from the charges for Locke's cousin, does a homicide investigation justify the police using a no-knock warrant within state restrictions?
Sure. I mean, it depends, right? When you think about the warrant inquiry, it's a 2-part sort of question in this case. Was there a probable cause to believe that the person who they suspected of this crime might be at the location, or was there probable cause to believe that there was evidence at this location? But then the no-knock inquiry is completely separate, and it is totally connected to the circumstances that the police are likely to encounter, right? Is there likely to be danger to life? Is there likely to be a loss of evidence? So that's a completely separate question. And it's possible to find that there is probable cause to enter a location or to seek entry into a location, but not that a no-knock is justified. And when you think about what was relied upon here for the probable cause, that has to inform to a certain degree whether or not a no-knock is issued. Here, based on media reports, it looks as though the suspect's connection to this apartment was that he had a key to the apartment. Well, what does that tell us? He had access to it, but it doesn't sound like they thought it was his primary residence. So was it justified to use this intrusive investigative tool that we know between 2010 and 2016 has led to the death of over 80 civilians and upwards of 11 or 12 or 13 law enforcement officers? I think it's an interesting question, and more so, other media outlets are reporting that the judge signed 2 warrants, right? One that gave the officers the ability to use the no-knock tactic if they encountered something that justified it, and the second that didn't. And we know that judges are supposed to make that decision based on what's presented during the probable cause inquiry. So the fact that these officers were able to just make the decision on their own and that deference was extended to them, I think that's improper.
Yeah, to drill down on that point, the interim police chief said that her department had both warrants requiring authorities to knock or not knock. Police chose the latter. How does that decision even come about?
It's an excellent question because I've never seen it. I've never heard of it. Based on how this should work, the judge is ultimately the person who ought to decide at the decision where that warrant is signed off on by the judge and police are given the opportunity to enter. That is the time that the judge is supposed to decide, is a no-knock warranted here? Are the police, is there sufficient reason to believe that the circumstances warrant entering this residence outside of the hours of 7 a.m. and whatever the outer boundary of that is? It is a judge that is ultimately to decide that. So to sign off on 2 warrants and defer the decision to the police officers, I've never experienced that in my career. I don't know if that is something that is typical in Minneapolis, but I certainly have never seen that.
Yeah, you have to wonder what the judge, Peter Cahill, of course, who was the presiding judge over the Derek Chauvin case, and so many people talked about the way he admirably conducted that trial. But whatever he was given, the information, you almost wonder if he's regretting that, because it only took 9 seconds to take a life when they could have done something else to save the life of Amir Locke.
Absolutely. And, hindsight is 20/20, and judges and a lot of folks in the criminal legal system make decisions based on the facts presented to them. And the problem is when those facts presented are problematic. We know in the Breonna Taylor situation, there was a question of whether or not suspicious packages were actually being sent to the apartment for the individual who was the subject of the warrant. There was no information about when the last time was that this person had accessed the apartment. And that's important too, because we have to think about how close in time is the information that's being relied upon. Is it too stale? Is it too remote? So, we haven't seen the warrant here, but one of the things when it is released that I'll be looking for is, when was the last time that, based on surveillance, was there surveillance conducted, right? Like, when was the last time there's, credible information that the person who is the subject of this warrant actually accessed this apartment? You know, was there surveillance that suggested that this person would be there at that time, right? When I have been involved in my career in these sorts of activities, there is a significant amount of surveillance that happens before you enter someone's home, and especially before you use this intrusive device that has proven time and time again to be dangerous to both police officers and civilians.
Yeah, the idea, Bianca, the idea of coming into someone's home is supposed to be sacred, and people also hold the Second Amendment sacred, but apparently it's not sacred when it comes to a black man. One of the other arguments where, we hear is that police make decisions based on a reasonable fear, and they may have had a reasonable fear as they entered that apartment that they needed to shoot their guns, but what if that reasonable fear is ultimately rooted in someone's skin color? How are you supposed to absolve that?
And that is why a lot of these decisions should be taken away from police officers and in some cases prosecutors until we figure out this bias problem. We know that bias is impacting how police is happening in poor, Black, and brown communities. And when you think about how bias is impacting so many layers of the system, we can talk all the way up to the death penalty, right? Because we see the bias play out in those decisions. And until we can figure out this bias problem and focus on identifying it and sussing it out, we need to limit the discretion that these people who are deputized to affect life and liberty and circumstance are carrying out, and they're doing so in a way that just demonstrates lack of training, lack of empathy, lack of an ability to see the communities that they're policing as human, and it really is devastating. In this case in particular, it just really breaks my heart.
Yeah, it breaks a lot of hearts. Again, you're echoing the sentiment of so many people saying pass the George Floyd Police Reform Act. Attorney Bianca Ford, we appreciate you so much for joining us, former federal prosecutor and global compliance executive. Thanks again for your perspective and being here with us tonight.